of the California Bar First Year Students Law Exam, and I'm going to go over this, and I want you to know that it's just a review, and you're welcome to comment on your opinion. And we're going to look at the model answer. We're going to go look at this student practice question that's taking the bar in November 2020. They told me that they moved it away from October this year. Okay, so this is a really difficult question. It is a long question. It's complicated. And one of the things that I advise this particular person to do, that is I've corrected their question, is to continue to work on the review and getting the speed up. Because this is what happened. They went through the question. They did a really good outline. Then they put in some stuff here that I thought was right, but I'm not really sure about it because the model answers don't have it. But the connections that she's making seem to be factual, but some of these applications are like, yes, you know the law, but do you need to talk about this? This is the question that I have, because I'm not seeing this at all in the model answers. Now, so this is a tough question. If you did this question as a practice question, I would say it's probably one of the more difficult questions. It might be even difficult for someone who's taking the regular bar and has gone through 3 years of law school, or 4, depending on what type of school they went to, or if they're doing like the, what's that program they have? The reader program, or where they're studying under an attorney. So anyhow, this question, you take it the same way you do all of them. You take a quick scan, and then you jump right down to the call of the question first, and then you read off the question. So let's read the question, and then go through the call of the question. So first, the call of the question is, under what theory or theories might Victor's parents bring an action for damages against Alice, Bob, and Carol? Discuss. Oh, I just love these questions. They're so broad. And it's got 3 parties and Victor's parents. So right now we know it's not criminal law, because sometimes there's overlap between criminal and civil. But here they're not accusing her of assaulting or anything like that. It's like Victor's parents can bring an action for damages against Alice, Bob, and Carol. Why is she this is Victor's parents, so we already know it's a minor child that was probably damaged, and we need to know the fact pattern and then apply it to the law. So right now we're thinking torts, right? And then they're saying, well, what defenses might they have? Might Alice, Bob, and Carol assert? So you got to break it apart. What might each person have as their defense? Well, you can only use defenses that the court allows. Well, when you know the law, you know which defenses the courts find as acceptable and which they don't, because we know the rule of law is not that simple. It may seem one way to us, but we want to look at what the courts have said and what the code says, or what the restatement says, or what the civil code is where they are. This is a civil case. It's not a criminal case. So let's take a look at this torts case. Let's read it. By the way, if you weren't following the other videos, I'm going to go over each of the 2008 practice released by the California Bar exams. And typically for the first year, they'll have 4 essay questions back to back, 1 hour per exam to write it all down and cover everything. And quite frankly, I've looked at this question and I think it's very challenging. Okay, so let's read it. Alice operates a daycare center in her home from Monday through Friday for children from ages 6 months to 3 years old. One Friday she discovered some mice in her house and called Bob an exterminator. Okay, there you go. You know Alice was one of the people that was going to be sued, and Bob the exterminator. So now you know why they're bringing Bob in. Something the exterminator did, maybe. Okay, she told Bob that she runs a daycare. So we know that she's operating a daycare center. We know there's a minor child involved, and the parents are suing. Okay, so let's go on. She told Bob that she runs a daycare center in her home for very young children and needs to get rid of the mice by the following Monday when the children will return. Okay, so right there, you can't have mice running around a daycare center, so that would be negligent too. So let's see what happened. Okay, on Saturday, Bob placed some small plastic packages of poison pellets around in the corners of every room in the house. He explained that the mice would gnaw through the pellets, the plastic packaging, to eat the pellets and then die shortly thereafter. On each package was printed the following warning: danger! This package contains poison. By the way, poison is misspelled, so I highlighted it. Don't let that throw you when you're taking the exam and there's grammatical errors or spelling. Just go over it. Just keep going. I mean, they have typos on their exams sometimes. Okay, so the poison, which may be harmful to human health if swallowed. Poison is misspelled. Don't let... Okay, I need to put this in red because I didn't mark it up right. Sorry, guys. Okay, before leaving Alice's house, Bob told her that the mice should ingest the pellets by Monday morning and that she could, if she wanted, to remove what is left of the packages before the children arrived. Now, on Sunday, Carol came for the first time to clean Alice's house. That is the third defendant, okay? So we're having a civil suit. It's a civil case. It's a tort case, I believe. I'm not seeing contract law here because I didn't hear a contract question. So let's go on. Now, of course, they do have a business contract, right? Because she's a daycare center, maybe. I don't know. Let's see. They have a business, she has a contract, Alice has a contract with Bob to get rid of the mice, and now she's got a contract with Carol to clean the house, right? So those are business contracts. But I'm still going with the torts. Let's keep reading. On Sunday, Carol came for the first time to clean Alice's house. Carol didn't know that Alice operated a daycare center in her home. Carol noticed several packages of poison in the corners of the rooms, but she cleaned around them. Now, shortly before the children arrived on Monday morning, Alice removed as many of the packages of poison as she could find. Later that day, 9-month-old Victor, one of the children in Alice's daycare center, was crawling along the floor of the living room when he found a package that Alice had missed. It had already been gnawed into by a mouse, and Victor reached in and ate some of the pellets. He became seriously ill. Medical tests determined that Victor's illness was caused by his ingestion of the mouse poison. Under what theory or theories might Victor's parents bring an action for damages against Alice, Bob, and Carol? Okay, so we know it is a tort now. There was a medical... He became seriously ill, and it was because of the poison, the mouse poison. So who's responsible for this poor baby getting sick? Let's write the fact pattern down the way they want you to see a lawyer analyzing the answer. Are you ready to practice law? Let's see if you can write like a lawyer in a lawyerly manner, zoom through the question right on the fly, analyze the fact pattern, show that you know it, and show the examiner you know it. Okay, so already they recognize that the question, and they're saying they've broken it apart really well. They've done Victor's parents versus Alice, and then down the line they did A, B, C. C, A, Alice, B, Bob, and Carol. So they're going to take each person and break it apart the way it is. And they've already said negligence. Is Alice negligent, right? Was she negligent to... Is she responsible for that baby? It's her daycare center, right? She called up the guy to bring the exterminating poison to get rid of the mice, and so she was negligent. Now let's see what this is the thing. I feel like this negligence definition could be a little briefer, and we'll go look at the outline right now and see what she could have written, not what she did write. So here, let's see. Okay, so negligence torts occur when the defendant's actions were unreasonably safe and the defendant breached their duty of due care. Now, one of the questions comes up, do they have a duty of due care? It's not coming up in this fact pattern, but sometimes they'll say, well, did they have a duty of due care? It's not coming up with Alice, but maybe it's coming up with Bob. He knew she ran a daycare, or maybe it's coming up with Carol. Does the house, the person that's hired to clean, do they have a duty to pick up the poison? Was there any instructions given to her? The fact pattern doesn't say that. So the parents are going to sue anybody they think might be responsible. That's going to get sorted out in court. But we'll find out what their defenses are when we go through it, right? So negligence is the defendant's breach of a duty of due care owed to the plaintiff. Okay, so it has to be owed to the plaintiff, and that's the key, because does Carol owe a duty? Does Bob owe a duty? Is he responsible for the baby eating the poison? He was just trying to kill mice, not make the baby sick. I guess I should finish this out. Okay, so this is the definition we're looking for. The defendant's breach of duty of due care owed to the plaintiff, which is the actual and proximate cause of the plaintiff's damages. And the plaintiff here in this case is Victor's parents. They're suing in behalf of their child, which has been damaged by the poison. I don't know how badly, they didn't say, but he had to go to the hospital, and the hospital determined it was the poison pellets. It's a good thing the baby didn't die. Right? And babies are that way, so let's go on. Whoops. By mistake, put it. There we go. Okay. So let's go back to the answer. Okay, so she's got negligence right. Now, immediately thereafter, she writes vicarious liability. Okay, she's saying that an employer can hold vicariously be held liable for the torturous acts of an employee within the scope of their employment. Okay, she did hire an exterminator, but she's not an employer, right? Is that an employer-employee Well, it's arguable. She says Alice hired Bob to exterminate the mice in her daycare home. And then she goes over to independent contractor. Usually not liable. She doesn't go into the fact pattern. She doesn't show how it applies. Now, I would stop right there because I don't know if this is really a business association's question. You could go into the fact that Bob is an independent contractor. He's not it's not an employer-employee, and normally you are held vicariously liable for the actions, the torturous actions of an employee within the scope of their employment. However, Bob is an exterminator and an independent contractor. She doesn't take out his taxes. She just gives him a check for his services. So she would write in there that, now I'm not sure, and if anybody has any opinion on this, whether or not she even needed to put that in there. Okay, landowner occupier, she's seeing that. See, now this thing that you've done here is you haven't put in enough meat in here. You've got the shell, you've got a great outline. I don't know why you didn't fill this in. So I guess what happens is, when you do go through it, you got to spot the issues, and then you put your shell outline, and then you go through it. So, but this needs work, and okay, let's keep going. Okay, so she talks about the landowner occupier. Let's take a look. I'll tell you what. We'll go take a look at the model answers. Okay. Let's take a look at the model answers. So basically, there's two model answers here. I looked at them. There's an answer A that passed. We don't know what the grade is because the bar releases the model answers that are the closest. And to have a passing answer, you can have a 70. So we don't know how perfect this is. We don't know if there's extra things in here that shouldn't be in here. We don't know if there's things missing in here. Okay? So here we have, on both of the questions, A and B, negligence, duty, and so on and so forth. So all three of these people agree that this is a negligence case, right? But interestingly, my friend brought up the idea of the vicarious liability, which is actually, when you have third parties and you have more than one person and you have a cause of action, it gets really dicey and complicated. So, do you put vicarious liability in there? Is Alice liable for Bob and Carol? So, I mean, it is a vicarious liability thing. I'm not going to argue that. I'm just thinking that maybe if it was broken like these, it would still pass. So let's take a look what this person wrote. For negligence is the failure to conform to the standard of care, the breach of which is the actual and proximate cause of the plaintiff's damages. Very good. Duty is owed to all foreseeable plaintiffs. Foreseeability is determined through the Cardozo and Andrews tests. Under Cardozo, a duty is owed to foreseeable plaintiffs in the zone of danger, whereas under Andrews, a duty is owed to all. Under the Cardozo view, Victor is a foreseeable plaintiff because he is a child in Alice's daycare's the zone of danger. Under the Andrews view, Victor is owed a duty. Therefore, a duty is owed to Victor by Alice. This is very nice. Now, there used to be, under modern law, one view was prevalent and then the other view was prevalent. And so the law changed over the years. So you could say modernly, too. Now, consider this, re ipsa loquitur. Okay, you might want to consider that. You might. Let's see if she put this in here at all. Oh, very good, very good. Okay. Remedies. Alright, okay, so let's just jump over here. We're not even looking at defenses right now. We're going to look at the three people's definition just for the very first one for Alice. You know, this would really take a long time to go over the whole thing. So what I'm going to do is I'm going to skim through here. So this is how they wrote this one that passed. Is Alice liable for negligence? Again, I looked at this before I came on. Each of them broke Alice. They broke up the three defendants, and then they analyzed the fact pattern under the three defendants. None of them found the issue of vicarious liability, and actually it is kind of an issue. Is Alice liable for the actions, you know, of the people she hired to come in her home? I mean, who's responsible, right? Well, we have to be showing logic in our steps for coming to our conclusion, right? So, they just put duty of standard and reasonable care. She has a general duty. She didn't say anything about special duty yet. Landowner's duty. A landowner has a duty to inspect any discoverable dangers and fix the dangers. Since this is Alice's home, she has a landowner's duty to remove all the poison pellets to avoid any harm done. Therefore, Alice has a duty as a landowner. So here is one of the things. My friend put in a business analysis because, you know what, there's overlap here. That's her home, and it's also her business. She works from home. Duty to an invitee. One has a duty to their invitee to warn of dangers, inspect any discoverable dangers, and to fix the dangers, right? Victor's an invitee to Alice's home because Victor is there for the purpose of Alice's supervision. Therefore, Alice has a duty to warn Victor and his parents of the poisonous pellet packages that were placed in the house, as well as to find all the packages remaining and remove all the remaining packages. Therefore, Alice has a duty to Victor as an invitee. Breach of duty. Boy, look how far, you know, breach of duty sounded. See how this is probably why she didn't finish it, because there's so much to get through, and you have to have your timing down, and you got to put everything out there. Okay? Alice may argue that. Sick. Okay, so basically, when they showed this as the model answer, they're showing that she was not grammatically correct. It's not a complete sentence. But that's okay because it's still passed, right? Therefore, Alice breached her duty. So this is a passing answer, and it's one of the better answers that they put up as a model answer. So my guess is that this was a really tough question, and a lot of people didn't pass this. Typically, with the first-year bar exam, a very small percentage of people pass these because they're almost at the level of a regular bar exam. So, now, factual cause, actual cause, proximate cause, but-for cause, so right here they said factual cause defined above, defined supra. So when they get to the second and third one, they start supraing them, okay, to get through it. Now what she did is let's see if she did any of that. I think I don't know what happened. I just put what happened. Victor's parents versus Bob, negligence, rule. See, all she had to do is go defined above, or supra, discussed above supra, right? And then she would apply the rule, right? Bob, you know, we can go through it all, but let's see what the others put, since she didn't put this in here. Now, she put something about the reasonable person here, which, okay, oh, I see. She did put discuss supra. Here, Bob's an exterminator, holds himself out as an exterminator. Bob can be held liable for any negligent actions that occurred in the course of his dealings that didn't follow the reasonable exterminator person's standard of due care. If a reasonable exterminator is supposed to come back, maybe is what she meant. To the daycare, he could be found negligent. However, the fact pattern indicates that Bob the exterminator informed Alice that she could make sure all the poison was picked up by Monday, before she opened, and each packet had a warning label. So basically, Bob didn't really say to her that it was bad, but it was written on the packet, and it was kind of inferred or implied. So it's a hazardous chemical, and she brings up Rylands versus Fletcher. They're saying that she's saying that Bob was dealing with hazardous chemicals on someone else's land, but he knew it was highly dangerous and he didn't come back to remove the poison. This is kind of giving him liability. Even if that was the industry standard, the poison was in the reach of the child, and a mouse could have moved the poison pellets around as mice do. This would be natural for the mice to do, or even after ingesting it. Thus, Bob allowed hazardous chemicals to be released in the area that he knew the young children were in, and that there was a chance it could harm them. Therefore, Bob can be held liable for an extremely hazardous chemical release on the property. So then we go through causation, actual cause, proximate cause. Again, she didn't do the whole thing. And this is the reason you need to practice, because even if you spot the issues, you've got to fill this in more, okay? So this is the defenses over here. This is a really, really tough question, and I'm not surprised that, but you're going to have to practice more with that. So there you go. You got to put the work in, you got to practice, you got to get your timing down. I like this. Under Judge Cardozo's proximate cause, the defendant is only liable for damages caused to plaintiffs within the foreseeable zone of danger. Carol will argue that Victor is not within the foreseeable zone of danger because she had no knowledge that Alice operated a daycare facility. Under the Judge Andrews proximate cause, the defendant is liable for damages caused to all plaintiffs. Victor will argue that under Judge Andrews' proximate cause, Carol is the proximate cause, depending on how the court follows the Judge Cardozo or Andrews. Carol may still be considered the proximate cause. So, there you go with all this. And, you know, you've got the assumption of the risk, the other type of defense. So these are the defenses that the law allows, depending on the state. And next time we'll go over question 3. If anybody has any concerns, questions, or if anybody has any opinions, certainly you're welcome to share them, or if something you think needs clarity. Again, there is the issue spotting checklist that has been created as well, and the model answers that are 70 or better, right? Okay, well, good luck. Thanks for listening. Take care. Bye.